Welcome to the Animal Wellness Podcast, all about improving the lives of animals with better policies and practices in government and business. Brought to you by Animal Wellness Action, where we believe helping animals helps us all. Here's your host, Joseph Grove.
Greetings, everyone, and welcome to the show. For more than half a century, the Endangered Species Act has stood as America's strongest safeguard against extinction. And one of its most important principles has been remarkably simple. You cannot save an animal while destroying the place it needs to live. But the U.S. Fish and Wildlife Service has now finalized a rule that strikes at that principle. Since the 1970s, federal wildlife agencies have interpreted the ESE's prohibition against harm to include significant habitat modification that actually kills or injures endangered wildlife by disrupting essential behaviors such as feeding, breeding, and sheltering. The new rule rescinds that long-standing definition, and it is scheduled to take effect on September 14th. The administration says the change restores the law's original meaning, protects property rights, and reduces regulatory burdens. Its critics, however, say it dismantles one of the ESA's most effective protections, potentially allowing logging, mining, drilling, construction, and other development to destroy the habitat of an endangered species, provided no one can prove that an individual animal was directly killed or injured. As wildlife writer Ted Williams explains in a forthcoming essay, which helped prompt today's discussion, habitat protection has been central to some of the ESA's greatest successes. Kirtland's warblers recovered because their jack pine habitat was actively restored, and red-cockaded woodpeckers rebounded through prescribed burning, protection of longleaf pine forests, and partnerships with private landowners. Without habitat, recovery becomes not merely difficult, but biologically impossible. And this policy reversal raises a particularly troubling question about the federal government's plan for the Pacific Northwest. The U.S. Fish and Wildlife Service has authorized a program that could kill as many as 450,000 barred owls over 30 years, ostensibly to protect northern and California spotted owls. The agency itself acknowledges that habitat loss and competition from barred owls are the two principal threats facing the spotted owl, and that protecting habitat remains necessary. Yet, at the same time, the same government is now weakening the legal interpretation that has allowed habitat destruction to be treated as harm. So, why contemplate killing hundreds of thousands of one owl species while weakening protection for the forests upon which the other depends? Well, to help us answer that question, I'm joined by four terrific guests. First up, Scott Edwards. He is our general counsel at Animal Wellness Action. He's an environmental attorney and an advocate with more than 30 years of experience in animal, community, and environment protection. For the past 2 decades, he has worked to advance and enforce laws safeguarding air, water, wildlife, and communities, including efforts to hold industrial animal agriculture accountable for pollution and animal cruelty. Ted Williams is a lifelong hunter and veteran wildlife journalist who writes exclusively about wildlife conservation. A former information officer for the Massachusetts Division of Fisheries and Wildlife, he currently serves on the Circle of Chiefs of the Outdoor Writers Association of America. Wayne Pacelli is the founder and president of Animal Wellness Action and the Center for a Humane Economy. He is a 2-time New York Times best-selling author who has been recognized 7 times as one of the nation's leading nonprofit executives. During his career, he has helped spearhead the passage of more than 1,500 state laws and 100 federal laws advancing animal protection. Heather King, known as the Owl Queen, is a wildlife activist, volunteer rescuer, photographer, and field observer. For more than 15 years, she has documented and protected owls through photography, videography, rescue work, and field research. She brings an on-the-ground perspective to owl conservation and has used her work to inspire public understanding, compassion, and action. Scott, let's start with you. Because in a recent staff meeting, you helped elucidate this issue in a way that really hit home for me. What exactly is the administration doing? What did harm mean under the longstanding regulation, and what does it mean now?
Yeah, Joe, thanks for having me on. This is a very disturbing rule change that the administration is proposing, is finalized now. They proposed and finalized it a couple of weeks ago. It is a fundamental change in approach to the way we've looked at the Endangered Species Act over these many decades now. For years and years, ever since the inception of the act, as you said in the introduction, harm, which is included in the statute itself, has been defined by the agency to include habitat destruction, because as you've said, you can't protect species, endangered, threatened species, or any other species, if you're going to go out and destroy the habitat upon which they rely. That has been essentially written in stone for these decades. As a matter of fact, the Supreme Court weighed in on this issue back in 1995 in a case called Sweet Home, in which they confirmed that in the face of challenges to that interpretation of harm, that the Endangered Species Act must include habitat protection. And that's the only thing that makes sense. Ironically, where the administration got this idea from is from a dissent by Justice Scalia in that same case back in 1995. And he was the only judge arguing that harm shouldn't include habitat protection. And the court just rejected that outright, as has every administration since that ruling and before that ruling. So we are looking at a fundamental change that is going to have a sweeping, if it withstands judicial challenge, is going to have a sweeping and absolutely destructive impact on all wildlife, including all wildlife protected under the Endangered Species Act.
Let me provide an extreme example to make sure that we're painting this appropriately for our listeners. It's like saying my good friend Ryan. Like, I can't do anything to Ryan personally, but if I want to burn Ryan's house down, that's okay. And if Ryan happens to be a casualty of it, then nobody's going to really pay much attention. Is that at all an accurate way to cast this?
Well, that might be a little bit of an extreme example. If you're burning Ryan's house down in order to get at Ryan, then no, that's not habitat destruction. That would be considered to be a take.
But I want his land, right?
Let's
say it's an eyesore. Ryan has a lot of inflatables at Halloween. I really don't like those, etc.
Putting aside that you'd be guilty of arson, I think that yes, you could destroy a habitat. Let's take the timber industry, for example. You mentioned the barred owl in the Northwest. What has stopped the timber industry to date has been laws that, like the Endangered Species Act, that stop industries from destroying habitat on which species rely and pretend that they're not targeting the animal. That the animals are under the law were called incidentally taken during their activities. So yeah, you can clear cut a forest now under this new law, which in effect is burning down Ryan's house. And if you happen to lose the entire population of owls or other species that inhabit that forest, then so be it. You're not guilty because you didn't target those animals.
Is the legal term for that a canard? Are we talking about a canard here, Scott?
You could use the word canard, sure.
Let me ask you this, and I don't want to get too wonky, but the administration technically rescinded the regulatory definition rather than rewriting the statutory regulation. Does that matter? Does that give hope to those of us who frown on this change?
Certainly. So the agency can't rewrite the statute. Only Congress can rewrite the statute. So this is a regulation, which makes it subject to lots of legal arguments, because an agency can't pass a regulation or change a regulation in a way that makes it not agreeable with the statute. So what this allows us to do and others to do is to go into court and say, no, the statute embraced a very broad definition of harm, and and application of harm. And the statute, Congress intended the statute to apply to habitat destruction. And there are other indicators that it wanted to protect habitat. And therefore, this new regulatory approach just simply doesn't comport with the statute and therefore should be undone by the court systems. I'm hopeful that argument will fly. And I think there's a good chance that it will at the district court level and at the appellate court level. This is an issue, though, that will undoubtedly end up back at the Supreme Court. I think that it is going to be a real battle before the Supreme Court when it does get there. Because, as I said, the foundation for this regulatory change is a Scalia decision that we know some justices on the court will go along with. And so I think we're already starting in a position in the Supreme Court where there are a number of justices who are very willing to embrace the Scalia approach, even if it means undoing precedent.
Wayne, we'll come back to you certainly to talk about the barred owl later, but I wondered if you had any insight or comment on the immediate topic of the regulation.
Well, we do know that a number of lawmakers in Congress have tried to advance a change to statute to affect this outcome, to narrow the definition of harm. They were defeated. And I think that is really a compelling fact pattern, because now they're just trying to change it through regulations, that the administration is saying, hey, we can do this on our own. I think that the history of failure is indication that other people thought that this should go through Congress, that it was too much of a reach. But Scott's going to be a better arbiter on whether that would put this rulemaking in jeopardy from a legal perspective. Having talked to Scott Edwards about this, I think he feels confident that we can prevail in U.S. District Court, perhaps the Federal Appeals Court that it goes to, depending upon the venue, that the Supreme Court is going to be a tough setting for us to prevail. Obviously, we're now approaching the 2-year mark of the administration in a few months. This is going to be President Trump's last term. Scott, I don't know what you think the timeline is, but this could push into the next administration if the district court, appellate court take quite a while to review the claims or the challenge to this rulemaking. And if that's the case, maybe a new administration can just pull the rug out from under it. I don't know. Do you think that's possible?
On the timeline, certainly it's not out of the realm that this does not see the Supreme Court for a couple of years. It could very well, though, make it then. In terms of the next administration undoing this rule, they certainly can. It would have to be a process. It would have to be what they call a notice and comment process, a new proposed rule. And that will also take some time. But your point, though, on when this has been discussed in Congress as a statutory change with this recognition that that's what it would take to change the approach that we've embraced all these decades, it is a very good point, and one that goes along with the fact that this is how the agency looked at this for decades. This is how the Supreme Court looked at this back in 1995. This is how everybody understood this to work, and that any change could not be achieved through simply a regulatory shift. That's a very strong argument as to why this court cannot undo all those decades of understanding. And that's why I say that I'm very hopeful that the lower courts looking at this will strike this rule down.
The United States history with wildlife is a very instructive one in terms of how we have structured our laws to address problems for wildlife. In the 19th century, direct killing of wild animals was an enormous explanation for scarcity and even extinction. We lost the Eskimo, curlew. We lost Carolina parakeet. We lost all sorts of species, the eastern elk, through too much shooting, right? We had a lot of habitat. And, in 1931, we had 31 million people in the United States of America. Now we have 340 million people. So multiply the people, with roads and with human settlements. I mean, we are really cutting up wildlife habitat, and we are running into animals with cars. Birds are hitting windows. Birds' flight patterns being thrown off by lighting. We're killing them directly, but we're destroying the forests. We're wiping out the grasslands. I mean, our evolving understanding of wildlife protection necessarily has meant, okay, we want to stop the direct killing, but we also need to protect their homes. And that's, Joseph, where you started the conversation. This is an attack on the core statute that protects the homes of wildlife. And it's something that is so fundamental to whether you're an environmentalist, conservationist, hunter. We all agree that animals have to have habitat. And this is a really important moment in the history of American wildlife policy and a significant case. And it's why Animal Wellness Action, the Center for Humane Economy, are going to be involved in this debate in a meaningful way.
You mentioned the word canard before. The Fish and Wildlife Service acknowledges that habitat loss is the leading cause of extinction. That there's no question about it. This is not a puzzle. This is something that the administration, this Fish and Wildlife Service does not deny, which is an admission that they are opening the doors for wildlife extinction.
All right, thank you. Now, September 14th is when the impact of the wording change takes place, if I understand that correctly, and I'm not 100% sure I do. Is an injunction possible, or is this a done deal and sky's the limit for these people?
No, certainly as part of a legal effort challenging this rule, and cases have already been filed challenging it, that an injunction is a possibility. The injunctions are tough to get when challenging regulations. They're rarely granted by the courts, but given, and you're correct, this becomes effective on September 14th, so 6 weeks from now. One of the factors that a court will always look like in deciding whether to issue an injunction is this concept of balancing the harms. What are the harms if I grant the injunction to the administration? What are the harms to wildlife if I don't? I think here clearly the harm to wildlife outweighs the harm to an administration, given the fact that before this rule was the way that we embraced habitat protection for decades. So I don't see a lot of harm in going back to where we need to be. I see immense potential for harm to threatened endangered species if we don't get an injunction on this rulemaking.
Thank you, Scott, very much. And you said something that really provides a terrific transition to Mr. Williams. Ted, given that habitat destruction is 80% of the culpability when it comes to species extinction, this change sounds holocaustic in its potential impact on animals. What say you?
Well, what this rule does is essentially does away with the Endangered Species Act. It's perfectly okay to destroy all the habitat that a species needs for survival, thereby rendering it extinct. You just can't harm directly an individual of that species. Trump's Interior Secretary Doug Burgum describes it as common sense. If this had been in place when the Endangered Species Act was enacted in 1973, maybe most of the listed species would now be extinct. Some of the most spectacular success stories of the Endangered Species Act wouldn't have happened. Red cockaded woodpeckers was a cooperative venture with the landowners to create and protect habitat of the red cockaded woodpecker, which depends on longleaf pines. because of these safe harbor agreements over 2.5 million acres, the bird recovered. And 2 years ago, it was downlisted from endangered to threatened. So that would never happen if Trump's rule had been in place.
Yeah. Well, let me ask you this too, Ted, because not only do we have the issue of the immediate harm caused when these species perish, for example, as a result of their habitat destruction, but we also have the animals in that habitat who flee and go to another habitat, right? So it doesn't only impact one area. What sort of problems do wildlife encounter when an animal is chased from one of its areas and suddenly finds itself trying to cohabitate with a different, potentially competing species?
Well, a good example is what Trump did 24 hours before the harm rule. He decreased the sizes of two national monuments in Utah by about 95%, opening them up to oil and gas drilling and uranium mining. So these endangered species that were on these monuments depend on buffer zones for their survival. These areas are no longer protected. Yellowstone National Park is a good example. Wolverines, Canada lynx, grizzly bears depend on the national forests surrounding the park for food and migration. And these areas will not be protected under the rule. So that's a direct impact on national park wildlife.
So I know, for example, there has to be a great deal of potential conflict and species become endangered. I have a stepdaughter who comes home from school and puts her backpack where I build my Legos because she can't put her backpack somewhere else. And sometimes there's unhappiness. What does that look like on an animal level?
Well, it looks like death because, when they lose their habitat,
which is what I keep telling her.
Die.
But yes, I interrupted you.
These animals are not, they don't, go by boundaries. The habitat is surrounding parks and monuments. And the Fish and Wildlife Service didn't just protect habitat because they wanted to. They were mandated by the Endangered Species Act. They had to do it. It was the law. All these prairie dog towns that had been protected and restored for black-footed ferrets are now available for poisoning prairie dogs and ranchers, real estate development, bulldozing.
You're listening to the Animal Wellness Podcast. We'll be right back after this quick word from our sponsor.
Animal Wellness Action depends on countless people like you to support our fight for animals. Join us today by donating to further our campaigns to spare countless animals from cruel and needless pharmaceutical tests. Put an end to animal fighting. Liberate farm animals from extreme confinement and so many others. Become a donor at any amount. Visit animalwellnessaction.org/donate to join our fight against animal cruelty of all kinds. Again, that's animalwellnessaction.org/donate. Thank you.
Now, back to the Animal Wellness Podcast.
So we've talked about the change in the regulation. Ted has given us, or at least in the definitions in the regulation, Ted, you've helped us kind of understand writ large why this is such a bad idea. Now I want to kind of drill down into the barred owl predicament. Animal Wellness Action has done a great deal of work educating people, a lot of work lobbying on behalf of the barred owl. So I want to hear from Wayne now about the barred owl campaign, and then Wayne, whenever you want to bring in Heather, she did such a great job for us on a webinar before. She tells so well what it's like to see these barred owls in person, what they're like. But Wayne, give us the update on the barred owl campaign, and where are you with that?
Well, I want to talk to you, Joseph, about the intersection of this Fish and Wildlife Service rulemaking to narrow the definition of harm and the 2024 Fish and Wildlife Service rulemaking to engage in native avian predator control by killing barred owls at least over 30 years. And it's really going to be an indefinite program. This really, I think, the juxtaposition of these two rules in the show today shows the hypocrisy, the inconsistency of the Fish and Wildlife Service. I mean, if the leadership of the Fish and Wildlife Service is okay with this idea of narrowing the definition of harm and basically like wiping away 95% of the value of the Endangered Species Act, why should we trust this agency? I mean, the barred owl kill plan in the hands of this Fish and Wildlife Service is just a tool for the timber industry to kill spotted owls through destruction of their habitat. And let me explain why. Under the Endangered Species Act, you're not allowed to directly kill threatened and endangered species. Two classifications, endangered being the more severe designation for the species. And as we discussed, the definition of harm means you're not allowed to destroy their habitat. And as Scott Edwards, our attorney, said earlier in the call, it was the concern about timber cutting of old growth forests that became a central question in the 80s and 90s when environmental organizations sued to stop clear cutting of old growth forests to save the spotted owl, that was going to violate the terms of the Endangered Species Act. That is the context for this broader issue about barred owls, where the Fish and Wildlife Service is saying, okay, we're going to kill barred owls because they're competing with northern spotted owls. And I agree that they're competing. There's no question that they're competing. But this was a timber industry idea to basically do a bait and switch and to take the focus off of the timber industry's cutting of forests. And this was built into a number of public lands agencies' resource management plans starting in 2015 and 2016. And the notion was they will agree to open up more habitats, cut down more old growth trees, if they can use barred owl killing as a mitigation measure to allow the so-called incidental take of threatened northern spotted owls. That's a mouthful, but think of carbon issues and think of the Clean Air Act, that you have a company that's polluting. It's dispersing toxic substances in the air, including carbon and perhaps methane. And under the Clean Air Act, there is potential for some of that if there's a mitigation measure, if you can sequester carbon or if you can plant trees. That is what the Fish and Wildlife Service was contemplating by killing barred owls, that because they're competing with spotted owls, we kill a whole bunch of barred owls. Therefore, we can use them as mitigation to allow for the taking of the habitat. Now we see that's exactly what's going on. They've had a two-track strategy to get to the old growth forest. One is use the barred owl as a tool or a key to unlock the taking of those forests, which in the One Big Beautiful Bill that was a Trump administration plan in 2025, they want to increase public lands timber harvest by 60%. We're now taking 3 billion board feet of timber from our public lands, and they want to increase that by 250 million board feet a year for each of the next 8 years, with each year being an additional increment of 250 million board feet. So by year 8, it's going to be 2 billion more board feet. We're blaming the barred owls as they're going to liquidate the forests? I mean, talk about blaming the victim. Barred owls moved because, like almost every species, they're range expanding with opportunity, whether it's forest fires that are driving them out, whether it's grassland, management practices that change and you have forest and they see opportunity because they're a forest owl. These animals are adapting just like hundreds of other bird species are adapting. If you look at the forests in Oregon, Washington, and Colorado, they have a whole bunch of different species than they used to have because animals move. The whole notion is just one of these archaic wildlife management notions from these reductionist managers that The species habitat is set in a book in 1900 or 1940. We're changing the environment. Of course, these animals are going to adapt. And as I said to Ted Williams when we were talking, because he and I don't see the barred owl exactly the same way, but there's a very rare porpoise in the Baja California area called the vaquita. There are only 40 of them left. That's because of commercial fishing and other commercial activities that have put these animals in danger. Are we going to say, okay, forget about the commercial fishermen. We're not going to stop them, but we're going to start killing sharks. Who put them at risk? Who put the vaquita at risk? And how are we going to control all those sharks in the open ocean? How are we going to control barred owls from Southern California to the border with Canada? The whole thing is ridiculous. It has zero chance of working. They have tiny little areas where they shot barred owls, and in a 2 or 3 year period, they noticed that you didn't quite lose as many spotted owls, but you didn't see any recovery of barred owls. So I think that this is wildlife management run amok. I think that these wildlife managers at the top levels of the administration should resign about this harm ruling. Brian Nislik is the former director of Wyoming Fish and Game. When Cody Roberts ran over the wolf, Thea, with a snowmobile a couple of years ago, Brian Nislik, the top wildlife official in the state of Wyoming, didn't say a word about it. Not one word. He didn't say, oh, this is terrible. This is cruelty. We should do better. He was silent. And now he's silent when the U.S. Fish and Wildlife Service is pushing ahead a plan to wipe out 95% of the value of the Endangered Species Act. And these are the people that are going to do the barred owl control with no data to support how the reclaiming of those areas where barred owls have been shot is going to happen. You can do your science to say, okay, you shoot some barred owls, you're going to have less competition with spotted owls. I accept it. But there's another scientific question, which is repopulation and juvenile dispersal. And their environmental impact statement said nothing about that. It said nothing about who's going to do the shooting. It said nothing about who's going to pay for it. And the Fish and Wildlife Service was in court against us in the U.S. District Court in Portland just 2 months ago. And they said to the judge, we need to kill barred owls to save the northern spotted owl. And then they come with this ridiculous plan to change the definition of harm. How can we take them seriously? Scott, am I wrong? How can we take these people seriously?
Yeah, no, I mean, you and I have talked about this. They showed up in court and said literally that the barred owl plan was our last effort to save the spotted owl. That we're at a point where we have to do this. While, as Wayne just pointed out, in their back pocket, they already had this change to the definition of harm, which is a death sentence for the spotted owl. And so Wayne began that talk talking about hypocrisy. It is the height of hypocrisy to show up in court and make that argument while they knew this rule was pending and was imminent. They have there is no way that the spotted owl survives this regulatory change. And that goes back to where I was saying before about the need to act quickly. If this is allowed to wind its way through the courts over the next 2-3 years without an injunction, it is likely that the spotted owl will be gone by then.
Yeah. And even the minutia of the plan, I sort of imagine a bunch of Elmer Fuds with the promise of a check from the government just wandering through the woods looking for something that may look like a barred owl and shooting it. Is it more sophisticated than that?
No, Joseph, they have to take a 30-minute online class. I mean, 30-minute online class. This is unbelievable. The training. I mean, I think the Navy SEALs should do this. I mean, rather than have them go to camp for 6 months and have their survival skills tested and drown these poor guys who are Navy SEALs, I think they should take a 30-minute class. And I think then we should send them out to, kill Osama bin Laden. The next Osama bin Laden. The whole thing is a joke. It's 30-minute class. Joseph, I want to ask, how are these people going to get into a wilderness area? We have a Wilderness Act. It's a roadless standard. Some of these roadless areas are 1.5 million, 2 million acres. How are you going to walk in? You're not allowed to use motorized vehicles. How are they going to walk into those wilderness areas in all those 17 national forests in the West where they're going to be killing barred owls, as well as 14 National Park Service units? How are they going to get there to kill those barred owls? Are they going to pack stuff in, go for a week and maybe see three barred owls? And, they're going to call them in with electronic calls, but others are going to survive by not answering the call. And the whole thing makes no sense to me. And I know Heather has such a great perspective on this because she spends time in the woods with owls. And she knows how difficult it is for owls to survive. She told me about the travails of the juveniles surviving. And Heather, I really appreciate the natural history that you have brought into this debate and this discussion about the barred owls and, talking about them as individuals. I think this is the problem with wildlife management. It's only about populations. It's not about individuals. And we have these archaic state fish and wildlife agencies, and we have archaic attitudes even within our U.S. Fish and Wildlife Service. And we need an ethic that is both a population-based ethic as well as an atomistic, individual animal ethic, that cruelty to wildlife should not be countenanced. It should not be countenanced. But Heather, I know you have a lot of thoughts on this issue.
I do. It's so tragic and heart-wrenching because the USFWS already spun the narrative for the barred owl to fail and people to buy what they're being sold before they even had a chance to do their own research. Most people have only heard one side. They're told the barred owl is the problem, and very few people have been shown all the factors that can affect the spotted owl populations. Now, the barred owl naturally expanded its range over time. It wasn't imported or released. Decades of old growth forests changed their habitat. We have 3 million hectares of forest fires in Canada. Can you imagine being a barred owl and fleeing to the south, escaping for your life with barely a few minutes left to breathe? And then the USFWS plays your hoot on a speaker and you traveled all that way and escaped the wildfires to be met with a bullet trying to answer a call. I just can't even conceive that this is happening. And they are not telling the public the full story. Anybody can access the app eBird, EBIRD. It's a bit of a learning curve, but you can see, and I have photos and videos to prove it, on the west coast of the United States, the great horned owl population triples the barred owl and the spotted owl combined. You can see that in real time on eBird. So the great horned owl is the top apex predator. It eats barred owls. I've seen barred owl facial discs at the base of great horned owl nests. It also eats spotted owls. You cannot lure a great horned owl out when it comes to you. They know humans are evil, whereas barred owls are too trusting. They're going to come. They're going to investigate. And the barred owls mate with the spotted owl, sometimes creating a hybrid species. So why is that important part of information being left out of the equation? Why are they not talking about how 1 in 3 baby barred owls makes it to their first birthday due to deforestation and the wildfires? There's so many puzzle pieces that they're not showing. They've just branded them as public enemy number 1. And it's like people like you and me, it almost feels like we're so many years behind, even though intellectually we're ahead of them because we know, but it doesn't matter how many, it sometimes feels futile. It doesn't matter how many videos I post are showing how much the mother will love the baby and how much that baby needs the mother and how mom and dad are there the first few months after it leaves the nest. They don't tell you that this is the most affectionate, loving owl family in all of the owls. I've done this for 16 years, and not just my own field experience, but even all of the nature documentaries I grew up watching. I have never seen an owl parent fly to its child 10 times in one day to calm its anxiety because it's scared it's out of the nest. They only have 28 days in the nest. And when they leave, their flight feathers don't work. They're on the ground. It's the least amount of time in the nest. There's another key thing I want to talk about too, and it's all barred owl families. They do not nest on the same schedule, just like humans when they have babies. Some barred owl pairs begin in March. They have their babies at the end of March, whereas other barred owl families will have babies in July. March, April, May, June, July, that's 5 months. And if you take into account that they need at least 3 months with mom and dad, like the window's over 6 months. How can you be doing this at all? Like, I don't even know where to go from here. I can't tell you how many tears I have wept. I will do anything. I don't even know what the next step is.
I want to ask you this, Heather, and then Wayne, I'll pop it over to you. But just it kind of goes back to my mental image of how this plan would even work. I have received many calls after we've posted a story on Animal Wellness Action where someone says, Joe, you guys put up a picture of the wrong owl. It's hard for us, and we post a lot of photos to tell that these owls are not one species or another. Is it how closely do they resemble other owls? And is it hard to make that distinction, even on the field?
I've never seen a spotted owl with my own eyes, but you can see from the pictures, it's impossible. In the dead of night, it's impossible even for the most trained person who's studied them forever. There's no way you can tell shining a flashlight. It's impossible.
Well, no, Heather, but you have to understand there's a 30-minute online course that the shooters are going to take. I mean, that is a fail-safe program for shooting the barred owls.
It's a master class. It's a master class, I tell you.
There's no verification by authorities that the person shot the right owl anyways. So it's all fiction, right? You can just go out and blast away at any owl you want and you'll get your bounty or whatever it is you're going to be paid. Or if the timber company's hired you because they want to clear cut that forest, no one's checking. So it really doesn't matter.
And I think the larger issue, Joseph, just to be perfectly serious about this, is that the barred owl plan juxtaposed with the definition of harm is really just an issue of deflection. It's really about let's blame this other species when it's humans who created this problem. The Endangered Species Act was designed to really stop human actions that result in species scarcity, wiping away their forests, shooting them into oblivion, doing whatever we're doing as a normal economic activity or kind of an intentionally malicious activity that puts species at risk. And why are we, I get that there's a legitimate discussion about competition between barred owls and spotted owls. I get it. And barred owls are more adaptive. Barred owls are real survivors. The spotted owls are more of a niche species and really prefer these older growth forests. But for us to ignore this larger set of threats to the spotted owl before the barred owl even got there. I mean, spotted owls were in deep decline. It's kind of like the vaquita. We're gonna now start killing sharks. We're gonna start killing. Where does this end? Because every mammalian, threatened or endangered species, every bird that's listed as threatened or endangered, they've got other animals that are competing against them. This is going to lead our Fish and Wildlife Service down a path to turn itself into USDA's wildlife services. Meanwhile, it's just going to be animal control wildlife control, and we're going to forget about the habitat. Again, this current leadership of the Fish and Wildlife Service, if they stay in power and accept this as a dictate from wherever it came from, whether it was Burgum as the Interior Secretary or somewhere in the White House, they cannot claim to be conservation advocates. And the whole argument about barred owls is really just folly at this point. It's folly.
All right. Very good. Thank you, Wayne. And Heather, you were so nice waiting until the end of the show for me to get to you. And you really are kind of representative of the heart of this conversation. Give me, as a final thought, your best case why anyone listening to this show should go out and make some action happen, write to their legislator, make some phone calls, make your best case for action for these poor owls.
Okay, there's a two-pointer for that. The first point is the body count is not going to be 450,000. It's going to be at least 1 million because barred owls have 2 to 3 babies every year. You can't find the nests. You can do the math there, plus the spotted owls, plus the other species. It's going to be 1 million. Let's be real. And the other is, would people change their minds if after the barred owls, they just put cats or dogs on the hit list? If cats or dogs were meowing at the side of the road and their pet came out and they were met with a bullet, would they change their mind? Would they stay silent? I know that sounds way out there, but literally this whole thing is so preposterous. When they're done with the barred owls and they're getting away with it, who's next?
Thank you for listening to the Animal Wellness Podcast. Please be sure to subscribe so you don't miss an episode, and follow Animal Wellness Action on Facebook, X, Instagram, and LinkedIn. To stay current with all of our news and information and to take action to help animals, sign up at animalwellnessaction.org. Until next time, remember, helping animals helps us all.